President Bola Tinubu on Friday administered oath of office on Justice Kudirat Kekereekun as the acting Chief Justice of Nigeria, pending her confirmation by the Senate. The swearing-in of the 23rd Chief Justice of Nigeria and the second female justice to hold the office took place at the Council Chamber of the State House in Abuja. In his remarks, President Tinubu urged the acting Chief Justice of Nigeria to defend the independence of the judiciary and promote the cause of justice. Before we speak with Liborous, let's listen first to the President.
Nigeria's acting Chief Justice Kudirat come to this position with an admirable family and professional pedigree. Over the years, she established a respectable and incorruptible reputation within the bar and the bench, which assert the cause of justice.
A better judiciary is for the benefit of the entire nation. Whatever the shortcomings that we see today, we're all members of the society. So if we want to see improvement, let the improvement start with each and every one of us and our approach to justice. Let us all also have faith in the system. And then we'll also be more particular about the process of appointment. I know it gives a lot of concern, discipline on the bench, at the bar as well. All these things are aspects that we will look into.
Let's now speak with Liborous Oshoma, a lawyer and public affairs analyst, on this latest developments in the judiciary. Good evening to you, Mr. Oshoma. Thank you so much for joining us this evening. Thank you.
Yeah, good evening. Good evening, my pleasure.
So we've seen the exits of Justice Kayode Ariwola and the swearing-in of an acting CJN, Justice Kekereekun. But Justice Ariwola is leaving the profession with very strong recommendations. So I'd like us to start from there. What do you make of these major recommendations?
You see, every Chief Justice that leaves would always make recommendations on what we should do. But unfortunately, it seems as if the judiciary, the politicians, day in, day out, year in, year out, are consistently, be turning the judiciary into a paper tiger. It's almost as if the judiciary that's supposed to be the last hope of the common man, the politicians are gradually turning it, if not have turned it, to the only hope of politicians these days. And no matter how good a judge is, the misgivings and the negativity, the judgments, the negative judgment that pervades the land, coupled with some political decisions that have been taken by the Apex Court, always have a way of rubbing off generally on the entire gamut of the arm of government, to the extent that people now think that there are no good judges, despite the fact that you still have a lot of good judges. And so recommendations for me, we should start from, really, if we truly want to look at it, you go to third schedule, the third schedule, part 1 of the third schedule of the Constitution. That's looking at paragraph 20. That's, for me, it's where we need to start from. That's really, it's where we need to start from. The NJC, it's saddled with the responsibility of cleaning the urgent table. And when you have a situation where almost 80 to 85% of the members of the NJC, by virtue of that paragraph 20 of part 1 of the third schedule, about 85% of the members are appointed by the Chief Justice of the Federation. This current set of leaders, when they were in opposition, they made robust recommendations on how the powers of the NJC should be whittled down. The powers of the CJN to appoint members of the NJC should be whittled down, coupled with the fact that the NJC should be allowed to sit just like a normal regular court, instead of sitting on ad hoc basis, so as to look into the issues of disciplinary measures against sitting judges. In the absence of that, there would be a whole gamut of impunity piling upon each other, and before you now deal with one, you will have about 500 resting on that. And so it becomes impossible, to take care of all of them. So that's basically for me what I see.
Do you consider this as the major task ahead of the new CJN?
It is not just a tax for the CJN. It is a tax for the president and a tax for the National Assembly, because it is the responsibility of the National Assembly to amend the Constitution, just the way they have, amended the law to, elongate the tenure of, has increased the salaries and allowances of judges. On the same vein, the way they have extended the retirement age of Supreme Court justices, it is also, there's need to amend that paragraph 20. Because quickly, permit me to read.
All right.
If you look at it, it says, the NJC, the National Judicial Council, the members shall comprise the Chief Justice of Federation, the President Court of Appeal, the five retired justices selected by the Chief Justice of the Federation, Justice of the Nigeria from the Supreme Court or Court of Appeal, the Chief Judge of the Federal High Court, the President of the National Industrial Court, 5 Chief Justices of the State to be appointed by the Chief Justice of Nigeria from among Chief Justices of the states, 1 Grand Cadi to be appointed by the Chief Justice of Nigeria from among Grand Cadi, 1 President of the Customary Court of Appeal to be appointed by the Chief Justice of Nigeria from among the President, 5 members of the Nigerian Bar Association who have been qualified to practice for a period not less than 15 years, at least one of whom shall be a senior advocate, appointed by the Chief Justice of Nigeria on the recommendations of National Executive Committee of the Nigerian Bar. 2 persons not being legal practitioners who, in the opinion of the Chief Justice of Nigeria, are of unquestionable character. So almost everybody here is appointed by one man. And we all know that when we say when power corrupt and absolute power corrupt, absolutely. So before now, it is the intention and the intent of the drafters of the Constitution that the ideas of a judge, the ideas of a judge are up in the heavens. And that's why before now you hardly see them. They live a very secluded life. But today, where judges are at the mercy of governors, of presidents, where governors will buy cars and gifts to president. You remember the case of Concord at the 9th Justice of the Supreme Court, where Concord published that the president gifted Justice of the Supreme Court Concord vehicles, and they felt the fame that, you can't say that they were gifted vehicles. But today, we see a governor handing keys to judges, and we just excuse it away. And you expect that, despite the clear provisions of the law, because if you look at that same, paragraph 20, if you go down on that paragraph and then you look at the functions of the NJC, you look at the powers of the NJC to collect, control, and disburse all monies, capital, and recurrent for the judiciary, to advise the president, to appoint, dismiss, and exercise disciplinary control over members and staff of the council, control and disburse all monies, capital, and recurrent for the service of the council, deal with all matters relating to broad issues of policy and administration. So when you look at all of this, these are powers of the National Judicial Council vis-a-vis the powers of the NJC. So when you look at the powers of the NJC and it deals with having to discipline judges, appointment of judges and the rest, and their finances of judges, and then you now see a governor gifting judges vehicles, and as if the money is his own. And sorry.
How detrimental?
Sorry, quickly.
All right.
Sorry, and so then you now talk about appointment of judges. How are they appointed? So when these things are appointment of judges these days, if you listen, you follow Professor Odi Kalu. Hello, can you hear me?
Yes, I can. Please go ahead.
So if you are a follower of Professor Odi Kalu, you will see that over time, there have been this cry on appointment of judges and the way our judges are appointed. And, in some cases, the appointment of judges has been turned to, family issues where the judge retires, they appoint their children and their daughters and, all what have you. So when you have all of those issues, appointment of judges are...
Mr. Oshoma, are you there? All right, so if you can hear me, Mr. Liborous, I wanted to ask how detrimental this is to the independence of the judiciary and, overall administration of justice in Nigeria. Are you there? Mr. Oshoma, can you hear me? All right. Mr. Oshoma, if you can hear me, I wanted to know how detrimental this is to administration of justice in Nigeria and the independence of the judiciary.
Yes, I can hear you clearly. And like I said, the first step, like I talked about disciplinary appointment of the members of the NJC. I also need to talk about the appointment of judges. Okay. So if the judges are appointed by who no man, a governor will recommend, outgoing justices will recommend their children. In such situations, it becomes a hereditary system of government where, to discipline. Who are you going to discipline? The politicians who influence the appointment of the judges when they err or when they run foul of the law. How will the judge, the same people who are going to discipline politicians who are appointed by the politicians, they are remunerated by the politicians, they are gifted vehicles by the politicians. So how do you expect such judges to discipline, or to disagree with the politicians when their matters come before them? That is how detrimental it is. So we need to go back to look at not just the law now, but also the orientation and the ideas behind, having judges of, unblemished record. And not just because, your children have been at home or they've been practicing law, they are called to bar. So you just, that pride of, saying that, my daughter or my son is a judge or my wife is a judge. It shouldn't be. It should be reserved for people who truly merit to sit on the bench. People whose ideas are up in the heavens. It's not necessarily also, it shouldn't just be for people who are, practicing lawyers. There are lecturers who have also excelled in the profession, who have also records are unblemished. They also can be appointed to the bench. Justin Taslim Olawale Elias was appointed as the Dean of UNILAG, straight from UNILAG to the Supreme Court bench. Until date, he's one of those judges that had distinguished themselves, exceedingly well at the Supreme Court. His ideas, his name still rings a bell in the gold of time. It still shines bright in the gold of time as a jurist, and not just in Nigeria, at international platform.
All right. I want us to talk about enormity of cases and appeals taken by the Supreme Court. Do you agree that the Supreme Court judges are overburdened?
My former boss, Festus Keyamu, SAN, when he appeared before the Senate committee that was screening him for ministerial appointment, he did say something, made robust recommendation, and unfortunately now nobody's looking at those recommendations. That there's need for us to have regional Supreme Courts. It is not every matter that should come before our Supreme Court. Let me quickly give you an example, and shamefully so. The appeal against the Code of Conduct Tribunal ruling or judgment on August matter was delivered. The judgment was delivered in 2019. The appeal was filed in June 2019, or May or so, 2019. Do you know that appeal that was filed in 2019 shamelessly came up for the first time this week since 2019? Wow. That is a former Chief Justice of the Federation. So if a former Chief Justice of the Federation's case can take 5 years to sit idle in one place, it didn't even come up for mention, not to talk of, for 5 years. So not to talk of the everyday person. And you know, the funniest part of it is that you steal a chicken, you are tried at the lower court, and the judgment is delivered, and it does not, you know, augur well with you. There's an allegation that somebody stole a chicken. I'm just giving you an example. The lawyers will appeal up to the Supreme Court. So that appeal for minor criminal offense and the appeal for serious matters, constitutional matters, are lying side by side at the Supreme Court. That is why in 2024, the Supreme Court will give you a date for 2027 because the court is overburdened. Let me tell you the enormity. Let me describe it for the benefit of our listeners and our viewers. Of all you have in Lagos State, for example, you have about the Lagos State High Court have about 70-something courtrooms. And then, apart from the Lagos State High Court, you have the National Industrial Courts. Then you have the the Federal High Courts. So cumulatively, you have more than 100 courtrooms in Lagos. And cases are recorded and registered and filed in these courts every day. So the appeals from all of these courts, we go to 2 rooms of Court of Appeal in Lagos, the Lagos Court of Appeal. Appeal from all of these courts. Yes, you might have 5 panels, but they have 2 rooms, 2 courtrooms. They take turn to sit. These are the people that will hear. So it is replicated across the various divisions like that. And then appeals from all of these Court of Appeal division, we go to just 3 courtrooms of the Supreme Court. 3 courtrooms. You can have 10 panel, but they will take turn to sit. Tell me how many times they go get to take care of the cases timelessly. So that is why we need to have regional Supreme Court. Not every matter should go to the Court of the Supreme Court. That is why now also, because the election, political matters, election matters, pre-election and post-election matters are time-bound. They are statutorily time-bound. You find the court, you know, bothered with, weighed down with political matters to the detriment of every other matter that is in that court. So every other matter will take the back seat, while the political matters will take the front seat. Because also, lawyers that are angling or they are struggling or that want the requirement of becoming a senior advocate, you must have, you know, have cases at the Supreme Court and the Court of Appeal. Frivolous appeals also are filed just for the application of sanction. So all of this will add to the already existing cases there.
Mr.
Why
Liborous,
would the judges be overburdened?
Justice Ariwoola has highlighted the need for virtual filings, comprehensive e-filing system. So how crucial is this to the administration of justice in the country? And it ultimately, I mean, applies to lower court as well.
You see, the e-filing, yeah, it will reduce the problem, but also it is not just about e-filing. Okay. It's not just about e-filing. Like I said, when you file all of these processes, is it not a court that will hear them? You file and then you leave it. Well, after filing, what happens to the matter? Lagos, for as long as I can remember, Lagos had been involved in e-filing, you know, because all of this will reduce the pressure on the judge. I agree, you know, to write in longhand. The records are already, you know, there online real time. That also might also help this duplicity of conflicting judgment, especially at the Court of Appeal and at the Federal High Court, where one matter will be filed in Abuja, another one will be filed in Port Harcourt or Lagos, and then one judge will give judgment to the other, will give another one, you know, conflicting on the same set of fact. But apart from e-filing, Lagos State has been, you know, e-filing has established e-filing for as long as I can remember. Lagos State also had be at the forefront of virtual hearing of matters. You know, you can be anywhere and testify, you know, in Lagos courts, provided the lawyer will apply, you know. But the Lagos State also had, by practice direction, you know, created segmented courts for as long as 20 years ago, where you have various divisions of the court. So you already know the division that your matter is going. But the question is, with the number of cases, the more judges are appointed, the more the cases keep coming. Despite the fact that even Lagos State also introduced alternative dispute resolution to reduce the pressure of cases filed. But you find out that the more the innovations, the more the cases. So these days, you have a matter that will drag on for 3, 4, 5 years at the lower court. If you remember, if you read Justice Fatai Williams' book, Cases, Places, and Faces, he said those days, in his time as a judge of the Federal High Court, there were days you will start a trial on Monday, and by Friday you are delivering judgments. You start a matter. Do you know? Then also, if you remember, the case of Ondo Election Petition Tribunal in 1978, Justice Orojo, if you remember, started hearing that matter on Monday. The governorship election petition, Michael Ajasi, by what do you call it, Saturday, the judgment has been delivered in the matter just 1 week.
Mr. Liborous, I'm sure we will continue this conversation some other time. Sadly, we're out of time. I do apologize.
At your pleasure, anytime.
I'm sure we'll continue some other time. Thank you so much for joining us this evening. I've been speaking with Liborous Oshoma, is a lawyer and public affairs analyst. Thank you so much. Please have a great weekend.
And you too. Always my pleasure.
And thank you for watching, everyone. That marks the end of today's episode of Politics Tonight. But you can watch the repeat broadcast of this episode at midnight. Get in touch with us on our social media handles, Facebook, Instagram, and X at TVC News NG and at Olajumoke using the hashtag Politics Tonight. We're also on YouTube at youtube.com/TVC News Nigeria. I am Olajumoke Olatuji. Have a great day.